I'm going to call this meeting to order. Today is Tuesday, October the 10th, 2023. It's 9 a.m. We're in the central jury room of the Ralph H. Walton Jr. Justice Center at 1200 West Pearl Street in Granbury, Texas. We're very pleased to have with us this morning Pastor Daniel Kraft of Granbury Heights Church with us today. I've been hearing about Pastor Kraft and his church for a long time now. He's got two very good members here, that the widows of Pastor Bill Miller, who is here all the time, and Pastor Larry Dixon, so very important people here. So we're welcoming you to do our invocation here, and his lovely wife with him today too. So thank you both for coming. Pastor Kraft.
Let's bow our heads in prayer. Lord, we thank you, God, for your goodness to us. Lord, we thank you for Jesus Christ, your Son. God, we pray for this city. Lord, we pray for Judge Massengill, the commissioners. Lord, give them the knowledge of right and wrong. Lord, I pray give them the wisdom to choose right. And Lord, we thank you for your goodness and your kindness to us in this city, for Hood County. Lord, we pray also for Israel, God, for peace there, and for peace for our allies, and for the women and children and those that are suffering. Lord, we pray and we remember them today. God, we thank you. Help us to avoid such bloodshed and catastrophes in our own nation. We thank you, God, for your goodness once again to us. And we say, your will be done. God, your kingdom come in Hood County. Let it be like heaven on earth. In Jesus' name we pray. Amen. And amen. Thank you.
Please join me in the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And now the pledge to the great state of Texas.
Honor the Texas flag. I pledge allegiance to thee, Texas, one state, under God, one and indivisible.
Okay. No awards or special presentations today. Okay. So we get right into the citizens' comments at large. And number one is Mr. Phil Harris.
Good morning.
Good morning.
I didn't expect to be first. My name is Phil Harris. I live in Pecan Plantation and have lived in Hood County for 22 years. I wanted to give a big shout out to the emergency services and the Pecan EMS. Last week I had a life-threatening event and they were there about 6 minutes after I made the call. They did a fabulous job, and I think they need a big pat on the back. So I wanted to say that publicly. Thank you.
Thank you very much. Phil is the newly elected president of the Sons of the Republic of Texas, too. I want to give you that honor, too, by the way. So, anyway. Item number 14, let me see. That's the only ones, Ms. Lang, am I right? That's the only ones on the open mic?
No.
Oh.
You signed up for the consent agenda.
Well, that's what I want to talk about, the consent agenda now.
All right, on the open mic?
We usually put open mic in.
Okay.
I never had to do it, so.
Okay.
Okay, we have marathon meetings here. My suggestion is that any renewable contracts be placed under consent. I'll pull them off the regular agenda. If you want to talk about them, they're still there. You can say pull them when you get to consent. But if they're renewed every year, just put them under consent. That's all I had. Save some time.
Good, thank you. I agree with you. Okay. All right, now that's it. So 14, 9, okay. All right. So next under here is, let me remind everybody again that if you want to speak on any agenda item, you must fill out a public participation form, hand it to the sheriff, and then the sheriff will hand it to Ms. Lang, and then you will get in line. And so far, I only have 3 participation forms for today. Usually I have 34 petitions by this time, but anyway, that's good news. All right, under miscellaneous, item number 1, discuss and take appropriate action to authorize the county judge to sign the City of Granbury's event application approving the request for use of the entire historical courthouse parking lot for the Harvest Moon Festival of the Arts beginning Friday, October 27th at 8 a.m., continuing Saturday, October 28th, and ending Sunday, October 29th at 4 p.m. I got an event application. This is something that's done every year here. It's a big event, and I move that we, Dr. Granick, did you sleep on this application here? Okay, well, it still passes muster, okay. I move that we approve or allow the county judge to sign the City of Granbury's event application for the Harvest Moon Festival at those dates and times.
Second.
Second by Commissioner Andrews. Okay. Any further discussion? All those in favor, say aye and raise your hand. Is Tina around there?
Aye.
Can you see that?
Aye.
I think that's unanimous. Passes 5-0. Okay, item number 2, discuss and take appropriate action to authorize the county judge to sign the City of Granbury's revised event application approving the request for use of the historic courthouse parking lot and gazebo for the Brazos River Corvette Club Charity Car Show on Saturday, October the 14th, 2023, from 6:30 a.m. to 4 p.m. We got an event application to that. Any discussion? Anybody here from the Corvette Club? If not, do I hear a motion?
I'll make the motion to authorize the county judge to sign the City of Granbury's revised event application, approving the request for the use of the historical courthouse parking lot and gazebo for the Brazos River Corvette Club Charity Car Show on Saturday, October 14th, 2023, from 6:30 a.m. to 4 p.m. and per the event application.
Second.
Okay, a motion been made by Commissioner Samuelson to authorize the county judge to sign the City of Granbury's revised application to use of the historic courthouse parking lot and gazebo for the Brazos River Corvette Club Charity Car Show on Saturday, October 14th, 2023, from 6:30 to 4 p.m., second by Commissioner Wilson. Any further discussion? All those in favor, raise your hand and say aye.
Aye.
All opposed? Motion carries unanimously, 5-0. Item number 3, discuss and take appropriate action to add Brazos Pregnancy Center to the list of agencies available to receive a donation of juror pay. Ms. Samuelson.
Yes, recently, actually during one of the budget discussions, it came up, actually, Tona was up here talking about, the district clerk was talking about a House bill that had changed some of the things regarding juror selection. And I noticed on the juror donation form a very good number of great organizations that do a lot for the community, but I did notice that the Brazos Pregnancy Center, who does quite a lot for the community, if you had just went to the gala that they had, it's amazing the work that they do, not just for the women and the babies, but also for the fathers. So what is on here that I took off of their website is the Brazos Pregnancy Center is empowering women and families through education and mentoring for over 25 years, provides free services, compassionate care, and resources. So I just thought when I saw this form and it was missing, and then going to that gala, that it should be an option. I mean, it's an option. There's many other charities on here, but if someone would like to donate their juror pay to the Brazos Pregnancy Center, it would be an option. So.
Any further discussion? If not, do I hear a motion?
So I'll make the motion to add Brazos Pregnancy Center to the list of agencies available to receive a donation of drawer pay.
Second.
Motion been made by Commissioner Samuelson to add Brazos Pregnancy Center to the list of agencies available to receive a donation of drawer pay, second by Commissioner Andrews. Any further discussion? All those in favor, say aye and raise your hand.
Aye.
Aye. All those opposed, nay, say nay. Motion carries unanimously 5-0. Item number 4, discuss and take appropriate action to allow the use of the courtroom in the historical courthouse for an area-wide hymn singing event on Saturday, December 2nd, 2023, from 5 p.m. to 7 p.m. Sheriff, I guess the only thing that we have up there, since it's in the evening at that time, is the security. And I think you stated before that it's $50 an hour, unless you have somebody that wants to donate it. That would be probably 3 hours to open and close up at that time.
Myself and Captain John Berry will take care of that, so
Oh,
we
great.
got that night covered.
So that's the security there. Appreciate that.
Who's
Thank-
the sponsor of this event? It wasn't on the agenda.
It didn't say. I didn't say who it was. It's a, yes, here, you come up here and meet. Speaking to the mic there, sir. Identify yourself, please.
Tim Berman, and I'm with the Downtown Church of Christ, just a couple blocks off the square, and we're hosting the event. But it's area-wide, it's open to anybody and everyone.
Okay. So you just want to use the courthouse, and I understand the courtroom upstairs. Is that correct?
Yeah.
Okay, and you heard the sheriff say that he and John Berry will provide security for that. Okay?
Excellent.
All right. Any further discussion?
Yes, Matt, can you come up to the podium? This came up a couple of courts ago when we had this is a little bit new, using the inside of the courthouse versus the parking area, and we brought up, there was a concern that I had about liability, but I think you've got a great solution for this, so.
Well, we discussed it in emails with Melissa, too. So some governmental entities will say you need an insurance policy so that if something happened, it would be covered under their insurance and not ours. I know, for instance, we talked about the Kiwanis Club has a 5K race that uses GISD property for staging, and we have to have an insurance policy for their purposes. But, of course, more things can go wrong at a race than a hymn singing, hopefully. So what was the suggestion was just a kind of a hold harmless agreement that says if they're going to use our facilities, and that'd probably be a good idea for anybody who uses our meeting rooms or any other group that would, indemnify the county. Theoretically, they could still file a suit, but it would at least probably rule out frivolous claims of things. So that would probably be a good idea, but not an actual financial implication for the group.
So it wouldn't cost the event sponsors anything?
Right.
Okay.
Right.
I think that's a great idea.
So what are you saying, Matt? If somebody wants to use, like this gentleman here wants to be able to use a courtroom, that he's going to have to make an application?
Well, I think everybody has to make an application of some sort, right, to use any meeting rooms?
No, we pass it right here. We allow them to use it right here in the.
Okay. Well, do we not have a form, or, is that not? Okay.
Not currently, no.
Okay. I think it'd be a good idea to just have a form for anybody using a meeting room.
Well, who's going to let them in? This is Saturday.
Well, the sheriff talked about, I think the sheriff and John Berry can cover that angle of it, but, to me, it would make good sense just for anybody to use our meeting rooms, just to say that, they don't hold us liable for any injuries and whatnot, and that they'll clean up after themselves and that kind of thing. That'd be pretty standard. I think we ought to probably do that for any group.
Yeah, I think you need to create that form post-haste.
Right.
And, that'd be applicable, from this day forward.
Sure, yeah.
You're the county attorney.
Sure.
You need to put that in,
Yeah.
that format.
Yeah, I didn't know that we didn't have that, actually, but, okay. I can
We
work-
haven't had it, I don't think, for 150 years.
Oh, okay, well,
So,
you know, it's a new day.
I guess it's never too late to have
Right,
this.
yeah.
Okay, but we do have insurance through TAC.
Right.
That covers all of this for everybody that comes in our buildings. This building, courthouse, any place else here. So there is insurance here. But
Right.
if you want to create that, and then
Sure.
we'll just have part of it when they come up here, we'll have them, when they, if it passes Commissioners Court, we'll have you go ahead and sign the form that will be created by the county attorney's office. So we'll have that for you to sign, okay?
That's fine.
And then you can just give it to Miss Lang. We'll let Miss Lang have it.
Okay.
Yeah,
All
let
right.
Miss Lang have it then, okay? All right.
So then
Any other discussion?
the motion would then be contingent on the hold harmless or on the form being filled out, is that what you're saying?
That's fine with me. I mean, approve it and then allow for them to sign a form later.
Okay,
Now, it's got to approve it first. Prove it
Yes.
first, then sign the
Yes.
form, then give
Right.
it to Miss Lang. We'll
Right.
have them here from now on at the meetings.
all
At
right.
the
Well,
Commissioners Court.
I'll make the motion to allow the use of the courtroom in the historical courthouse for an area-wide hymn singing event on Saturday, December 2nd, 2023, from 5 to 7 p.m., contingent on hold harmless application.
Second.
Okay, motion been made by Commissioner Samuelson to allow the use of the courtroom in the historical courthouse for an area-wide hymn sing event on Saturday, December 2nd, 2023, from 5 p.m. to 7 p.m. Second by Commissioner Wilson. All those in favor, say aye.
Aye.
All opposed, say nay. Motion carries unanimously 5-0. Okay, item number 5, consider and take appropriate action to authorize the county judge to sign the 2024 Hood County Resolution for the Indigent Defense Formula Grant Program. Okay, this is something that's done every year. It's the same standard form, is it not? So I move that we authorize the county judge to sign the 2024 Hood County Resolution for the Indigent Defense Formula Grant Program.
Second.
Second by Commissioner Wilson. Any further discussion? All those in favor say aye.
Aye.
All opposed, say nay. Motion carries unanimously 5-0. Okay, item number 6, authorize the county judge to sign the Savins First Contract Renewal Participation Entity Service Agreement. Again, this is something that's done every year. It's the same standard contract that we do, is it not? Yes, sir. Okay. Again, I move that we allow the county judge to sign the Savins First Contract Renewal Participation Entity Service Agreement. I hear a second.
Second.
Second by Commissioner Andrews. Any further discussion? All those in favor say aye.
Aye.
All opposed, say nay. Motion carries unanimously 5-0. Item number 7, discuss and take appropriate action to nominate candidates for the Hood County Appraisal District Board of Directors for 2-year terms beginning on January 1st, 2024. I think that we have 2 nominations that are in our packet here. One is for Greg Harrell, and the other is for Rod Litke.
Judge, I'm going to make the motion that we nominate both of them to send them back to the appraisal district.
I second that motion. Okay, a motion been made by Commissioner Eagle to nominate both Greg Harrell and Rod Litke as candidates for the Hood County Appraisal District Board of Directors for 2-year terms beginning January 1st, 2024, second by County Judge Ron Massengill. Any further discussion?
Yeah, Judge, just quickly. So this is a process we go through every 2 years. And this, all we're doing today is nominating 2 people that we had 2 applications come in during the period of applications. It goes back to the appraisal district. They will compile, the school district's doing their list, the city of Granbury is doing their list, or has done their list, and we send this back to the appraisal district. They'll compile a list of all the nominees. It comes back to all the entities to vote. That's it. Thank you.
Okay, all those in favor of nominating Greg Harrell and Rod Litke for the Hood County Appraisal District Board, say aye. Aye. All opposed, say nay. Motion carries unanimously, 5-0. Okay, item number 8, consider and take appropriate action to increase fire protection budget 5430-49500 insurance by $20,000 from Fund 55 for volunteer fire department insurance policies. Jeff Young.
I apologize. I hate to break up the feng shui because y'all were like on a roll and I had to come mess all that up. So we have 3 insurance policies that we cover for most of the 9 departments. It's auto, workers' comp, and accident and sickness. Last year's insurance was $185,000, $146. I'd asked for $200,000 this year, thinking that would help cover any increase that might be out there and when they add or delete vehicles. We do not get our premium bill on the auto policy until the week before our budget goes into effect. So come October 1, I get the insurance bill for the auto policy and find out that we are $20,000 over the amount that I'd asked for, and I'd asked for almost $20,000 more than we had last year. So right now, our budget line is $200,000. I've got $218,322 in invoices for the auto policy. So I'm having to ask for an additional $20,000, which will leave me about $435 for vehicle changes or whatever.
Can I make a suggestion? Instead
Yes.
of coming out of capital projects, let me do a budget amendment and decrease general contingency and increase your insurance line instead of using capital projects.
You are the magic lady, and I completely trust you, and however you want to set that up.
So Commissioners, if you would make that a motion.
Yes. Yes, I'll make that motion. I make the motion to increase the fire protection budget 5430-49500 insurance by $20,000 from the general contingency fund 01040949700.
Second.
Okay, a motion been made by Commissioner Samuelson to increase the fire protection budget insurance by $20,000 from the general contingency fund, second by Commissioner Wilson. Any further discussion? All those in favor say aye.
Aye.
All opposed say nay. Motion carries unanimously.
Thank you, sir.
5-0. I'm sorry you're not clairvoyant. You do a good job as fire marshal.
Yeah.
If you were clairvoyant, you've been able to predict that back in September.
Well, there is one thing I have asked the insurance company to do is to start getting my bill ready like in April or May, so I'm not surprised with being over budget the day it starts.
Yeah.
And we're working towards getting that done, so
think they
hopefully
could-
this will be the last time I have to ask for this.
Yeah, they
All
could
right.
at least
Good deal.
give you
Thank you.
an estimate on the percent increase earlier.
Well, so I figured it up on average, going back to 2020, we have increased 22.9% annually on all three products. So I had a long discussion with them last night about stop breaking stuff and stop getting hurt.
Yeah.
Thank
Hopefully
you.
that'll help.
Okay. Item number 9, discuss and take appropriate action to modify the rules of procedure, conduct, and decorum at meetings of the Hood County Commissioners Court. We have several people that have signed up to discuss this item. Number 1 is Brad Yarborough.
I was hoping Yarborough could discuss it first.
Okay, well, all right. All right. You brought this up, Commissioner Samuelson. so-
Yes. First, I want to thank Commissioner Eagle for putting this discussion on the agenda last court, just to have a general discussion. And I want to thank the members of the public and the court that participated in the discussion regarding Robert's Rules of Order. It was apparent that those who spoke from the public supported a more respectful and orderly conduct during Commissioners' Court proceedings. So I drafted a revised rules of decorum and but I also have provided some additional information from the Texas Association of Counties, which I'm going to hand out right now. So first, I wanted to go over the information from the Texas Association of Counties, because it may actually change the suggested changes that I had made earlier that was attached to the agenda. So on page 4, Procedurals, Best Practices for Commissioners Court from Texas Association of Counties, if I call your attention to that, top of the page, Presiding Officer, middle paragraph. The judge's decision and rulings on procedures are final unless overruled by a majority vote of the court after a motion to challenge the procedural rulings. Then on the bottom of page 13, general expectations of courtesy and respect. A policy on respect for the court and citizens may also help meetings to be more orderly and productive. Such a policy may require individuals to refrain from using the public meeting as a forum for rude, slanderous, or disruptive personal attacks on others, and may allow the presiding officer to take the floor away from individuals who act unruly. Individuals may further be prohibited from private discourse or other distractions, and any such acts may be stopped by the presiding officer. Although the Open Meetings Act does not address behavior or conduct of the public, other laws do. In Texas, it is a criminal offense for a person with the intent to prevent or disrupt a lawful meeting to substantially obstruct or interfere with the meeting by physical action or verbal utterance. It is a best practice to issue warnings for disruptive behavior before taking further action, such as expulsion, arrest, or finding contempt. So then on page 6, item 2, this is addressing people speaking during public comments. One at a time, the presiding officer should invite the appropriate individuals to offer their comments, information, and/or recommendations. As each speaker concludes, the chair should ask members of the court if they have any questions. Note, this is not a time for back-and-forth discussion, but only a time for questions directed to the individual, offering comments, information, or recommendations to the court. The speaker should be given the opportunity to respond to any questions. And then just quickly glancing, I think if you were here or watched the video, you saw that during the discussion on the Robert's Rules of Order, I provided a cheat sheet for the Robert's Rules of Orders. But also the Texas Association of Counties also has the same, almost the same procedural rules cheat sheet. And just glancing through it, there is a discussion on point of order. It talks about to object to a procedural or personal affront, there would be a commissioner or anyone on the dais could call a point of order. It would be interrupt the speaker. It does not need a second, and then the judge would decide as the presiding officer. However, there could be a vote on a ruling by the presiding officer. If a person said, I appeal the judge's decision, could interrupt the speaker, does require a second, is debatable, and it would be a majority rule. So one example that the Texas Association of Counties gave on point of order says, when it is obvious that a meeting is not following proper rules, without recognition, someone would call a point of order, one of the people on the dais. And then without recognition, if there was a ruling, without recognition, I appeal from the decision of the chair. So those were some, as you all probably know, I do a bit of research when I prepare for these meetings. And I was pretty, I guess, I was glad to see these rules that were in the Texas Association of County example of the rules of procedure, because it really, after I saw those, I'm not sure I need to change, or I would request that we change very much on our current rules. So let's go, and I would appreciate, discussion on this. As you also know, I'm very much a proponent of having citizens' comments and discussion, because I think we learn from that. We just need to ensure that it's civil and not unruly. I really want to hear from the public. So the changes, okay, so Drew has put up the changes that I had proposed. And so one of them is to add this section 5. All members of the court and public are expected to conduct themselves in a manner that demonstrates respect towards others and the court itself. Behavior that impedes or disrupts the business of the Commissioner's Court while court is in session is prohibited and unlawful pursuant to Texas Penal Code 42-05. It is the intention of Hood County Commissioner's Court to attend to county business effectively and efficiently without undue interruption. Cell phone usage during Commissioner's Court is strictly prohibited. All cell phone pagers and other mobile communication devices should be in silent mode at all times while court is in session. And that was pulled directly from the Texas Association of Counties model order. And when I was talking to the gentleman there at TAC, he was a little surprised that we didn't already have that in there. But this version of the Texas Association of Counties model order was changed last September, so not that surprised that we didn't know or have it in there. The second section, based on what I just read that's covered in the procedures, we can discuss. I'm not sure we need it. Each member of the public who has completed a public participation form will be called on to speak by the presiding officer. When the speaker's name is called, the member of the public shall speak at that time or pass. Once the member of the public has chosen to speak or pass, this will fulfill the speaking opportunity on that particular agenda item or the public comments at large. But if you remember what I read back here when it was talking about one at a time, the presiding officer should invite the appropriate individuals to offer their comments, information, and/or recommendation. As each speaker concludes, the chair should ask the court if they have any questions. Note this is not a time for back and forth discussion, but only a time for questions directed to the individual offering comments, information, or recommendations to the court. The speaker should be given the opportunity to respond to questions. So maybe we do or don't need that, or maybe that belongs on the application, on the form that you fill out when you request to speak. So the last change on the next page, which after reading the updated form and the cheat sheet, and I'll leave it up to the court whether we need it or not, but if at any time a member of the Commissioner's Court observes the rules herein documented not being followed, any member of the court shall be authorized to call a point of order to request a ruling by the presiding officer. Any member of the court shall be authorized to move to overrule the presiding officer's ruling. Upon receiving a second, the presiding officer will call for a vote. The presiding officer's ruling can only be overruled with a majority vote, and that's exactly what the TAC rules provide for. So that's what I had. And again, I really want to thank everyone who came up and spoke at the last court. Really appreciate the responses of people wanting to see a more professional discussion and order in the court. And so that just made me go back, and I listened to what you say, and I went back and did some research, and this is what I'm bringing for discussion today.
Okay. The first person that has signed up is Mr. Brad Yarbrough.
Thank you, Judge, Commissioners. As I'm for decorum in the court, that document you just put up is kind of contradicting. You're saying there's no back and forth, but then y'all want to be able to ask questions, and for the speaker to answer, that's going back and forth. So I don't understand that part, or how you're going to get around no back and forth. My next issue is it's not really the speakers that are violating rules of decorum. It's mostly you elected officials. You have, when the judge says you're out of order, that's a hint to be quiet, no more talking, to silence yourself. And you've had some people jump across the table to call people liars that are elected officials. You had others, and when the judge is saying you're out of order, they keep talking. And it's not us if anybody's ever, I've never been told I was out of order, but if any other members in here said they're out of order, they stop talking, except for you elected officials. I think you need to have rules for the elected officials. When you're out of order, it's time to be quiet. And the biggest violators there's 3 people in this room that are elected officials. So I would like to see some kind of rule for that. Thank you.
Okay. The next speaker is Tina Brown.
Good morning. I also did a little research. I do that too, and I found those same things that you spoke of. And a couple of them, I only saw 2 changes on the document. Did you make a third change later on the hyperlink?
I passed it out to the members of the court. The first section was too late to make it for the 72.
Because I thought, how did I miss that? Because that was not included in what I had read. Before we do any more adding or changing to this document, I think maybe we should have some sort of committee or a workshop. There's many things that could be changed or enhanced. For instance, the dress code in more detail. Also, the use of cell phones by the court during court. I don't think that's appropriate. I'd like to see the agenda items handled more uniformly, like read the item, have the sponsor explain the item, then have y'all discuss it so we know what your viewpoint is before we get up here and speak, and then have us speak. It's just like, that happens sometime, but not on everything. So I'd like that to be a little more uniform. I didn't really understand this part that you said about the participation form. I thought that was it's kind of what we already did. You know, he calls us up here as, so I didn't really see, that just seemed like it was already taken care of. But this last one about overruling the judge, this is going to be, this could have some unintended consequences. Right now, it's a 3-2 court. Last court was also a 3-2 court. So this could be, I don't think this is a good idea. I think it's just going to make the division in this county worse. I think we should really think about before we do that. Thank you.
Okay. Thank you. The next speaker is Dr. Harold Granick.
Thank you, Judge, Commissioners. I hate to slow down a process that a meeting that's going with such alacrity. We could set a record today, but on this point, Commissioner Eagle a few weeks ago said one of his proudest moments was introducing the open mic. And I agree, that was a good thing because it allows the public to talk. I think anything that potentially suppresses that open mic is worrisome. The judge was elected at large by all the population of the county, and therefore, in some sense, should have greater powers. I think the point of order, raising a point of order, will slow down the whole process of open mic. And if 3 people are on the Commissioners Court say, well, my pal's being criticized, so let's stop that, that would be opposed to the concept of open mic. So I think the rules we have, as long as they're respected, have been very good. It's when those rules we already have haven't been respected, they're a problem. As to whether someone is speaking in an unruly fashion, it reminds me of the Supreme Court, and I'll paraphrase it, when they discussed pornography, and they said, I'm not sure I can define it, but you recognize it when you see it. We can tell when someone is being unruly. Someone could certainly, if they're being criticized, can say, oh, well, that's slander or such, and that member of the audience being restricted would be worrisome. So I would like to leave the power with the judge to make that decision and not to be overruled by points of order, which in decades of having to deal with Robert's Rules of Order have noticed that tends to delay things, not to make things more efficient. So, and now with that, I'll leave my time so we can continue to have a rapid meeting. Thank you.
Thank you. Well, that includes the speakers on here. Any further discussion?
Yeah, I'd like to, I am absolutely in favor of the public comment, and criticism is absolutely part of that. If somebody wants to come up here and speak directly to a vote that somebody's made or a position that somebody holds that's sitting on this commissioner's court, or you know, for that matter, any elected official in the county, any part of county business, that is specifically lined out in our rules and procedures that it needs to pertain to county business. I have seen individuals that weren't even in this courtroom lambasted from that podium, and that's not okay. Nobody was stopped on that. There needs to be a mechanism to correct that kind of behavior. This isn't for political stump. This isn't for somebody to come up here and bash another individual or tell you why not to vote for somebody. That's not what this is about. This is about conducting the county's business, and we need to get this thing reined in. I think everybody we have business to do here, and we need to conduct that in a professional way. This gives an opportunity to or better defines the procedure on how to do this. This is not new. Robert's Rules of Order has been around for however long, and this document has been what other counties do. This isn't anything new. We're just getting on the bandwagon here and being able to run meetings properly. We don't need all this side stuff. We need to come in here and do county business. Criticism of an elected official, criticism of what we're doing in here is absolutely, and it even says in here that criticism should be allowed to go on. But, you know, if somebody comes up here and just starts calling people names and stuff, that's not okay. That's my 2 cents.
Anybody else have any other questions or comments?
Yeah, I got a couple. So as Commissioner Samuelson pointed out, you know, last court we had for discussion Robert's Rules of Order. And it depends on what seat you're sitting in, whether you think some of this is getting out of hand or not. And under Robert's Rules, your group, let's just look at Robert's Rules for a minute. Your group's bylaws are your first go-to. And we don't have bylaws, we have rules of decorum. And were we abiding by our rules of decorum as stated, then there would be no problem here. But I think some of us perceive that there may be rulings or allowances for one side of the political docket and not on the other. And For instance, when we had a speaker come up here just a minute ago and referred to three of us with a little bit of a backhand comment, see, that's the kind of stuff that we need to stop. I don't mind, and I want to go back to the rules of decorum here. Item number 4, the business of the county. This is an Article 5 court. It's made up of 4 commissioners and a county judge. The county judge is just a member of this court, and he's the presiding officer. If you go look at Robert's Rules of Order, and you look at the proposed changes that Ms. Samuelson, which I appreciate all the work she's done, she didn't even go to Robert's Rules. She went to TAC, Texas Association of Counties. And if you go to any TAC meeting, which I was at one last week, and Mr. Jim Allison happened to be there, if you've been to one of these commissioners' conferences, which I know that none of you have, but everybody on this bench has, and the first thing that when he talks about what the Commissioners Court does is he raises 3 fingers. 3. And what that means is 3 votes get something done up here. And our rules of decorum, we drafted them, we vote on them, we post them online, and we are supposed to adhere to them. In my opinion, some of our meetings have gotten to be somewhat of a free-for-all. And I will compare this. You go up to the city council and see if you can get anything out your lips like some of the stuff I hear at this podium. We've unbelievably give you unbelievable latitude up here to say a lot of stuff. Go to a school board meeting and they're going to shut you down in 1 minute. So compared to those 2 entities, we not only offer 1 open mic since Commissioner Samuelson got on here, 2. I agree, open mic is an important part of our political process and the process of running this government. We need to hear from people. We need to hear what you're thinking and what your suggestions are. But we don't need you coming up here calling everybody a bunch of names, calling out people, looking behind you and calling out people in the audience. That's not appropriate. If you were in a regular court of law, you would get called for contempt. So I support these 3 changes in our rules, and Robert's Rules of Order has a mechanism for overruling a presiding officer. And contrary to one of the persons who said something, he does not have the power over anything but to preside over this meeting. And a presiding officer is always subject, always, to being called out for a point of order. So I think that in my book, for instance, when you come to speak, you come up here and speak. You go back and you sit down and you're done. Talking from the audience after that is not appropriate. Go up to City Hall and see if you can do it up there. Go over to the school board and see if you can do it there. They'll escort you out. So I think that putting this in writing is just something apparently that needs to be done. But the bottom line is this: we're up here to conduct the business of the county. And for most everything, we get it done. And we have differences of opinion, and we have disagreements up here. I welcome disagreement. That's what makes this government function, is disagreement. If we're all up here singing the same tune, you better watch your pocketbook. And I'll say the same for the school board or the city. If they're all up there chiming in with the same song, then you better watch your bank account. So I welcome dissent, criticism of a vote that I take or a position that I take, bring it on. But coming up here and calling me a liar is not going to fly. Thank you.
Any further discussion? Anybody have any other comment?
Yeah, I think, given the comment that was made previously by one of the speakers, this does call at this point for a workshop or at least further discussion. and I so move.
Okay, we got a motion by Commissioner Wilson to move for a workshop concerning adopting the new or amended rules of procedure, conduct, and decorum at meetings of the Commissioners Court. Do I hear a second? I second the motion. Any further discussion?
Yes. We have workshopped this to death. We came in here, this is our rules of decorum to run this court. And we appreciate the input, but we don't, in my opinion, we don't need any more workshops.
Any further discussion?
I agree with that. We had a really good discussion last court, and, you know, I think we heard from quite a few people on what their thoughts were, and their thoughts were that we needed to have more order in the court and have a better running business meeting. This is a court, and we need to treat it as such. So those are my comments.
And one last thing, we don't need to kick this can down the road any further.
Well, I got something to say. Well, I've just been handed a bunch of additions this morning by Ms. Samuelson, so I haven't even had time to read what have just been handed. I've been in this court here for 5 years, and I've heard Commissioner Eagle say many times, well, I haven't even had time to look at this. I think that we need time to study these rules and see how they interact together before we try to vote on something that we haven't even had an opportunity to study. That's something that we've just got, and we're just now trying to read these rules, and of course, we want to try to act on them. We haven't even had a chance to look at them. So for that reason, and that reason alone, I think that we should have an opportunity to look at these rules and have a clean copy of whatever that we're voting on. So for that thing, I think that I say that we should table this until we have a chance to have a revised set of rules to see what we're actually voting on.
Point of order, you have a motion and a second.
I've just given my opinion. You
Okay.
give your opinion, I'm giving my opinion.
Oh, I
That's what
thought
I'm
you
saying.
moved for, you made a motion to table.
Well, that's what it is.
No.
I call for a workshop, and I still stand by that motion.
Okay, workshop, okay. All those in favor of a workshop regarding the rules of decorum and procedure, say aye. Aye. All those opposed, say nay.
Nay.
Okay. The nays have it 3-2. Okay. I make a motion that we table this motion until we have an opportunity to have a complete written set of the rules that we are going to be voting on one way or another. That's what I would like to see done after we have consideration on it. So I move that we table this until the next meeting of the Commissioners Court to see what exactly are we voting on. So I make that motion. The motion to table has been made, second by Commissioner Wilson. Any further discussion?
Yeah, that, you know, Judge, I think that that's okay. I have, at different times, I'm ready to move on this, but at different times, it's been, why do we have to do this right this second? If you need more time to go in and look these rules over and make sure that this is where we need to be and interject on that, I'm good with that.
Okay. Anybody, any further discussion? Okay, with not, all those in favor of tabling this motion until the next Commissioners Court, say aye. Aye. All opposed, say nay.
Nay.
The ayes have it, 4-1. Okay. Next item, item number 10. Receive update from grant writer on the following specific grants that have been applied for, including potential award and timing, grants currently in process and on the horizon. Ms. Margaret Campbell. Ms. Campbell.
Hello, Judge, Commissioners. I'm not Emily, but Emily had a prior obligation that she really needed to meet, so I said that I would come and speak on her behalf for you guys. She's been here for exactly 3 months today, 65 work days, and so far she's done quite a bit. She's applied for one grant. She turned it in officially last week. If we receive it, it's a $2 million award. We don't know exactly when it's going to be determined. They say fall. What fall means to the government.
Fall of this year? Okay.
But we're not exactly sure when. Other grants she's looked at are wildfire mitigation grants. She looked at a feral hog grant. She's looked at energy improvement for rural counties. What else? Flood mitigation, traffic safety grants. I mean, the list goes on and on. But so far, there's only 2 that she has worked on actually applying for. One she turned in last week, and then the other is Senate Bill 22, which is not open to apply for yet, but she's gathered all the information, she's talked to all the right people. So as soon as it opens, she should be able to turn it in the same day.
And the one that's the $2 million grant, what is the subject of that grant?
It's a transportation grant. So it's focusing on improving transportation in rural areas. If we get that grant, it opens us up for a possibility of getting to apply for a second grant, which is a larger amount of money. Only the people that receive grant or the phase 1 get to do phase 2.
And Senate Bill 22 is, could you explain that?
Senate Bill 22, it is a $500,000 salary assistance program. It has 3 different categories. One is the sheriff's office, one is constables if they are primarily doing traffic stops, and one is the prosecutor's office. She's gathered all the information for it. She has everything ready to submit it, but it's slated to open January of '24.
And so we've already met the salary requirements, so as such, that $500,000 could be used for equipment that the sheriff's office needs?
I believe so, yes. It has to stay in that same budget because it's basically, it's just assisting that organization. But yeah, it should be able to use for equipment or other needs that the sheriff's office has.
Yeah, and just talking with the sheriff last week, that is already, there is already a placeholder in our budget, assuming that that grant will be received. So Fund 106 in our budget is a placeholder for that $500,000 to be used for whatever equipment or that the sheriff's office that falls within the purview of that grant.
Yeah.
So that's something that the legislature provided, and for a county of our size, is $500,000.
Yep.
And we talked about this grant last week at the West Texas Commissioners and County Judges, and it needs to be ready to go on the 1st.
It is ready to, I mean, if it opens today at noon, she could turn it in at 12:05.
Okay. All right, good.
She has everything lined up, and all she's waiting on is them to give her the green light.
So a few weeks ago, the Upper Trinity was here, and they were talking about the rainwater reclamation grants. Has she had a chance to work with them on that?
She's been looking at water conservation or water reclamation grants. There's nothing open right now, but she did, let me find it, tell me that she saw one that opens, I think it's early 2024 that she's looking at, which should be a pretty good option. We got to make sure that it's in the best interest of the county as far as matching or requirements, regulations, things like that. But she seems excited. She seems like it's a possibility.
Good.
Yeah. Any other questions I can answer for you guys?
Thank you.
Awesome.
Good deal. Thank you
you,
very
guys.
much. Okay. Item number 11, discuss and consider for approval the removal of the 2 concrete pads by November 1st, 2023 from the Hood County Courthouse Square as instructed by the Texas State Historical Commission. Mr. Jay Riley.
Morning, Judge, Commissioners. As you know, we need to remove the 2 slabs from the courthouse. I do not have a price. I've reached out. I'm trying to do that, but we'll have to go through the, I'll have to get some bids on this to put it back exactly the way we found it. So it's, I'll have to put it through the bidding process and find out what it is. I can't honestly give you a number. We do not have the equipment to do that job in the county.
Do you think there's a chance it won't be done by November 1st?
It's possible. And the reason why is because of the guy, there's so much construction going on around here, it's just nearly impossible to get anybody. To me, it's a big job. To them, it's a small job. And so it's kind of hard to do. So there's a possibility we won't be complete. But my biggest concern is the holidays are coming up. There's a lot goes on that courthouse during the holidays. If the Historical Commission holds their feet to the fire on this, and I presume that they will, we're going to have a mess.
I think what we can do is just try to see what kind of bids we do come in. And one of the most important considerations is when can it be completed? And if they say it can't be completed by November the 1st, maybe we go ahead and apply for an extension, given the fact of the holidays coming up. And I do believe that the relationship that Hood County does have with the State Historical Commission, I can't believe that they would not give us an extension, given the fact that we've been trying to accomplish the removal of the paths. We're not trying to stonewall it at all. We've been trying to do it. It's not our fault. We just have to have the right equipment and the right person to do it, and we haven't been able to do that. So as long as you continue to try to do that and keep us updated with that, and I'll take the initiative and you can tell me about it. And if we see that we can't, because I'm like you, it's better to leave the two paths alone rather than to get the equipment moved out there and have that
taking up the parking lots.
Yeah, taking apart during the holiday season.
During Santa's
for sure.
workshop and everything else.
So, my plan is we're going to have to bid this. It's going to be enough money that I'm thinking 3 bids is what I'll have to do. So I reached out to the first guy. I was trying to get you a figure to go by this time, and I do not have that. So I don't know that there's any action needs to be taken on it other than I need to come back with the dollar value at this point.
I think you're just going to have to come back with the bids as soon as you can get some.
Yes, sir.
And then we'll take it from there. We'll just have to maybe vote on it to ask for an extension.
Right.
Okay.
I just wanted everybody to know we're working forward, so.
Well, you're doing a good job. It's nothing you can do about it since the county doesn't have the equipment, okay?
We don't.
So I'll make a motion to table this removal of the 2 concrete pads by November 1st until such time as the maintenance development can have bids for approval.
The
Yes,
motion been made by Commissioner Samuelson to table the removal of the 2 concrete paths by November the 1st until the further meeting and further information, second by County Judge Massengill. Any further discussion? All those in favor say aye.
Aye.
All opposed say nay. Motion carries 5-0. Thank you.
I appreciate it.
Thank you. Okay. Item number 12, I pulled that motion because that cannot be done by certain of the government entities. So that brings us to number 13. Discuss and consider for approval amending the interlocal agreement with the City of Granbury relating to the enforcement authority of the extraterritorial jurisdiction, better known as ETJ, agreement. And I recognize Chris Kaufman from the city and Jeremy Sorrell, city attorney here, esteemed members. Please.
Thank you, Judge. First off, I just want to thank the court for always working with the city and trying to streamline everything that we do together. And the ETJ is also known as the extraterritorial jurisdiction. The recent legislative session went into effect September 1st. that allows for individuals that are located in the ETJ to petition the city to be removed from the ETJ. And we've received several applications for that since that time, which in effect makes our ETJ more like a piece of Swiss cheese with holes in it, which makes it very difficult to do the planning that our interlocal agreement provides for. So what the city council has done is we've had a couple of committee meetings with the judge and appropriate staff, and the city attorney has worked with the county attorney's office, and we've drafted an agreement. I hope you have a copy of that before you in your packet. If you don't, I've got another copy for you. But basically what we're proposing to amend the agreement to do is listed under 2.1 of the agreement, 2.2, and the rest is pretty much, well, 2.4. And what we discovered through the meetings is that the county does have a thoroughfare plan, and it mirrors the cities. So that's good news for everybody involved. But we're proposing that the city no longer do the plats for the subdivisions in the ETJ and allow the county to take care of those under their rules and procedures and your court orders, and also to enforce that thoroughfare plan, just like the city has that agrees with your plan. So be happy to answer any questions you may have, but this is really an opportunity to change the way that we've been doing it for a couple of decades. This mandatory agreement that we have was passed by the legislature in 1999, and we had to have an agreement on the books by April of 2000. And so this agreement has been in effect one way or another since that time. And with the city not being able to do anything but voluntary annexation, there is no reason for the city to be dealing with matters outside its city limits. And so we do have some provisions in this agreement for folks that are under development agreements to be annexed at some point, and we will retain those platting responsibilities. But anything that's not under agreement currently, we would need to turn over to y'all. Additionally, if we negotiate with someone that actually wants to be in the city, we would notify you of their intent to annex and turn that project over to our city staff as well. So be happy to answer any questions. Jeremy's here as well. This is just really time to make a change.
Okay, thank you. Anybody have any question?
Yes,
Comment?
I do. So just to be sure I understand, the purpose of this agreement really eliminates the need for people to opt out, because it's like opting everybody out at once, except for the people that are contractually obligated based on.
It still leaves them in the ETJ, but it removes our responsibility to provide hodgepodge planning because of the Swiss cheese that I spoke about.
So then why would anyone need to opt out after this?
I don't know, but they probably will.
Okay.
We have people out recruiting citizens to pay them a fee to perform the service of being opted out of the ETJ. So free enterprise is alive and well in Hood County.
But if
I've
their
got no problem with
purpose of opting out was to be under county regulations versus city permitting, and then after this, there's really no reason for them to do that, if that was their reason. Do I get that right?
That's one of the reasons.
Okay.
That would be correct in any of the ETJ except those that are under contractual obligation, development agreement, or were placed in the ETJ by operation of law through some sort of a court order through litigation, that they cannot be removed, or anyone who has voluntarily annexed themselves into the ETJ. We do have one piece of property where the folks came in and said, here's a written consent, I want you to take us into the ETJ. The city would continue to enforce its authorities in those areas of the ETJ, but the remaining ETJ would fall under the purview of the county.
Okay. So I just have one comment, and if this is a draft, I would recommend we either state that this replaces there's no reference to the existing interlocal agreement, that this is replacing it, or just our county attorney suggested that we write on here that this terminates, this agreement terminates and replaces all previous agreements on this subject matter.
So this agreement actually doesn't do that, and the
Okay.
very first word at the top of this is amended. So there's the reference to the prior agreement.
But it doesn't have the
This is
date.
This is the amended agreement between the city council and the City of Granbury Commissioners Court on this issue. So
Okay.
that's already handled.
So we won't have two concurrent agreements with conflicting agreement language.
You will have your original agreement and the amended.
Okay, so there are some things in the original agreement that will still be intact.
Effectively, no.
Okay.
I mean, this is a very simple agreement. We're basically saying, instead of the city enforcing it, the ETJ, the county is.
Right, I
and included the
Right.
provisions for the thoroughfare plan.
I understand the agreement, I just want to be clear that we don't have two concurrent agreements with conflicting language.
Well, Alan and I went through this. I don't think there's a misunderstanding about that.
Mr. Mills, you want to come up here?
amendment to the
There's no
previous
misunderstanding by me either. I mean,
Judge, I pretty much gave this to Alan, and he was the one who met with y'all. He's my assistant, so I didn't really have hands-on on this. I mean, I could probably go dig him out of the office if we really need it, but.
Well, he's the one who
But he approved
suggested, he's the one that suggested that we ask the judge to write on the agreement, this agreement terminates and replaces all previous agreements of this subject matter.
I would hesitate to say terminate, because the statute is very clear that you can't terminate it without, our previous agreement requires 45-day
Yes.
notice prior to the existing agreement.
I saw
So
that.
if you do that, we're not going to be able to execute this for 45 days.
I saw that, so that was,
So that's why we proposed
con-
to amend it. Anytime you amend an agreement, you go with the final words of this agreement, and it supersedes the conflicts from the previous agreement. I'm not a lawyer, but I'm
Why don't we
just
put
saying,
that,
play one on TV.
242 requires notice, so.
Okay.
so why don't we just put that sentence in there? To the extent this conflicts with the other agreement, this agreement controls. This amendment controls. How about that?
I think that's a good idea.
You know, I think it's semantics. We're willing to do whatever you need. Oh, seriously.
That's all lawyers deal with is semantics in a big way.
We're happy to, as long as y'all are going to start doing this at a certain date, that's what we need to determine. And I thought when we execute it, then it's all yours. So we're not able to do that if we don't have a final agreement today, so.
So we could do a 2.5 and just say any conflict with the prior terms
well, I have a
is
suggestion, Mr.
superseded by
Mills.
this addendum.
Mr. Mills, why don't you take it and give it to Alan and see if that's all right for him to.
What Dave suggested sounds reasonable to me, and the city seems to be okay with that, and then we can get it done, right?
Look, Judge, there are no substantive changes. If it's something that makes the court feel better for whatever reason.
That's fine.
Put in unnecessary language that says that all prior agreements are terminated, or however you want to fashion it.
I don't think it's unnecessary
And the word
language.
terminate.
Yeah.
Everybody
Well,
knows that's
why don't you
going
just
against.
interlate it into any end? We've got a couple of more items, and we can just sign it here today then.
Yeah, just handwrite it in, and then you,
Right, you didn't say terminate, Dave, you just said.
Supersede.
Yeah, just, if there's any conflict,
If there's a conflict,
this
agreement-
this addendum controls.
That makes sense.
It's not, you know.
so what's the language, Mr. Eagle? Commissioner
The
Eagle?
extent
I'm just
there-
going to write 2.5 and say this agreement supersedes all prior agreements.
Okay.
That's it.
Okay.
Judge, may I approach?
Here you go, yes. Okay. This agreement supersedes all prior agreements, okay? So we've all seen this, so with this one addendum to 2.5 that states this agreement supersedes all prior agreements, do I hear a motion?
Yes, I make a move that we approve the amended interlocal agreement with the City of Granbury relating to the enforcement authority of the ETJ extraterritorial jurisdiction as amended with adding 2.5.
Second.
Okay, motion been made by Commissioner Wilson, second by Commissioner Eagle, to approve the amended agreement between the City Council of the City of Granbury and the Commissioners Court of the County of Hood regarding the ETJ agreement. Any further discussion? All those in favor say aye. Aye. All opposed say nay. Motion carries unanimously 5-0.
Judge, if we could, we'd like to have a few more comments related to planning, and we'll be done.
Just
Okay.
briefly, this has been a topic of several joint meetings, and we're happy to finally get this worked out. You got a little help from the legislature on this, so there really wasn't much choice. But the city's hope is that moving forward with this, that you guys will put together a development committee as you're allowed to by law, and that you will start actually developing the county in such a way you have the authority to create development regulations, even though a lot of people don't believe you do. You can zone. It's called districting in the statute. You have special authority to do that. And Judge, I'm telling you and the court that I would offer my assistance and assistance from the city. We have a comprehensive land use plan. The county has the authority, not just the authority, but the obligation to create its own comprehensive land use plan, and we hope that you guys will move forward with this, as well as ensuring the protections of our lake. The legislature, and I don't often say this, actually had enough of foresight to look at Hood County some years ago and say, you have a watershed and you have a lake water issue, and we need to protect that. And they granted you these special authorities for zoning and for regulations in the county, but we don't see any of that. So there are certain requirements that they are congruent with each of the city's land use plans. We want to work on that with you. Our land use plan is available. I'll be happy to sit down with any of you and go through it. Mr. Kaufman as well. He's always agreeable to sit down with you guys. We want to create a congruent plan for not just the city of Granbury, but for the county, working with you doing that, as well as protecting the lake. Certainly we would hope, there was a recent piece of legislation you guys passed regarding on-site sewage facilities that I believe is a detriment to our watershed and is in direct contravention of this legislative code under 321. I would impress upon each of you to go read 321 and look what it is for. It is for the protection of our water, our watershed, and our lake. Our lake toxic levels are at a number that created such a question in the mind of the legislature, they created this legislation for you to protect that.
Point of order, is this on the agenda? I'm sorry, point of order. This is not on the agenda. But this isn't about the ETJ. He's gone off of
It is.
this.
It's about the ETJ in the entire county, and the city's extending an olive branch, wanting to assist the county and bringing to light some things that we would like for you to look at in the further enforcement of growing our county. The lake is responsible for recreation. We don't want to lose that. It's responsible for economic development. We don't want to lose that. The tourism will be lost. If you have a home on the lake, what are your land values going to do? You're going to lose those. I would just impress upon you to look at 231, create this development committee that you're allowed to do, consider zoning, consider development in the county, and let us work with you to help develop those regulations for the best interests of the entire county. Thank you, Judge.
Thank you. Okay. All right. Okay, item number 14. Discuss and consider for approval displaying 4 signs on the historical courthouse grounds from October the 15th to the 31st, 2023 to promote a, quote, Skeletons for St. Jude's Hospital, end quote, fundraiser. Got Mr. Brad Yarborough.
Yes, Judge, thank you so much. I want to apologize ahead of time. I get kind of choked up when I talk about this charity. Y'all know St. Jude was founded in 1962 by Danny Thomas, and their mission is no child is denied treatment. And they've been a phenomenal charity since '62. When they started, the childhood survival rate, childhood cancer, was 20%. It is now raised up to 80%. And they just do amazing work. So how Skeletons for St. Jude came around was there's a guy in North Carolina, and his name was Jeff Robertson. And he had this amazing Halloween display, and it got national attention. And he was like, hey, I want to capitalize on this and do this charity. With just that 1 year, this was in 2020, he raised $8,000 just by himself. And then since then, he grew this charity. In 2021, they raised $151,000. Last year, I got involved with it. We raised $214,000. And so far this year, we are up to $67,000, and we're hoping for almost $300,000 this year. So what I'm asking is if we can put out 4 signs around the courthouse, and here's a sample of the signs. And it has a QR code, and you can scan that code, and it takes you directly to my page on the St. Jude website, and it tells you my mission, why I started it. It shows you my display that I have. And last year, like I said, I started this last year. Last year, I raised a little over $600. My goal was $500. This year, my goal is $1,200, and I'm hoping for $1,500. And hoping to put some of these signs around the courthouse will help with that. Like I said, it's a great organization. I'm not asking for any money. I'm just asking to put up 4 signs around the courthouse. And I asked for the, from the 15th through the end of October. I saw that y'all approved the charity event for the 14th, so if y'all approve this, I'd really like to get out there on the 14th of the Corvette thing and kind of help get more attention to the St. Jude charity.
Okay. So, any comments or questions?
Where will
We
the-
got one more speaker.
Where will the signs be?
Anything else?
Well, I did talk to the city. The city said there was no permit needed. All I had to do was get approval from the Commissioner's Court, and so then we can put up the 4 signs. Again, this is one of the signs that will be put out there. This one's not 2-sided, but all 4 of the ones I'm going to put out in the courthouse will be 2-sided. It'll be exactly like this. Again, you can scan it. I urge all of y'all, please scan this. The audience, please scan the QR code, donate. Every little bit helps, $5, $10. Like I said, it goes to awesome charity. 100% goes to St. Jude. Nobody gets, there's no middleman, there's no anything else. It goes directly to St. Jude.
Mr. Yarborough, are those, where will they be placed, outside or inside the courthouse?
Outside, the 4 corners on the lawn, and that's why I didn't need permits, because it's on the lawn.
Okay.
Well, thank you. Thank you. Okay, Dr. Granick?
Thank you, Judge and Commissioners. I have a special place in my heart for this charity. It's one of the best I've ever known. I dealt with the children with eye cancers when I did my fellowship. My only concern is we leave the skeletons here in Granbury, and we have only healthy children leaving the hospital at St. Jude's. Thank you.
Okay. Any other comment or discussion? If not, do I hear an appropriate motion?
Yes, I move that we approve the displaying of 4 signs on the historical courthouse grounds from October 14th, correct, instead of the 15th, through the 31st, 2023, to promote Skeletons for St. Jude Hospital fundraiser.
Second.
Okay. Motion has been made by Commissioner Wilson to approve the displaying of 4 signs on the historical courthouse grounds from October the 14th to the October the 31st, 2023, to promote Skeletons for St. Jude Hospital fundraiser, second by Commissioner Andrews. Any further discussion? All those in favor say aye.
Aye.
All opposed say nay. Motion carries unanimously 5-0. Thank you very much. Okay, item number 15, Discuss and consider for approval the use of the historic courthouse and courtroom for a Texas Independence Day presentation to the public by the Sons of the Republic of Texas, Davy Crockett Chapter, on Saturday, March 2nd, 2024, from 10 a.m. to 1 p.m., and a rehearsal on Friday, March 1st, 2024, from 5:30 p.m. to 6:30 p.m. Mr. Phil Harris, do you want to talk about this? The president, newly elected, of the Sons of the Republic of Texas.
Thank you very much, Judge. So this will be the 6th year that we've done this in Granbury around the courthouse. We've done it outside the courthouse on the south side and on the north side, and contending with the traffic and the Harleys. We've done it in Celebration Hall a couple of times, and we did it upstairs in the courthouse last year. The first year we did it, we were hoping to get 25 or 30. We had about 50 people. And we've been growing. Last year, my view is we hit a home run. We really advertised it, worked hard. We had about 150 people in the courthouse. We had 7 displays on Texas history in the courthouse, including a flag display. And so it was well attended. And you know you've hit a home run when the group sticks around for a while and wants to talk to you. And they did.
Yep.
So appreciate this effort.
Okay. Any further comment or discussion? If not, do I hear a motion?
Well, there's the Sheriff Deeds. This is about 4 hours, so the cost to provide security is about $200.
I think you provided security last year for this, didn't you?
Yes, I did. So
Okay, are you planning to be there for this?
I
or-
will take care of both days myself, so then there won't be any cost in it.
Okay. And then,
He's a real friend to our.
yes.
Yeah.
Thank you.
He likes those Rangers, though.
Right. And Mr. Harris, you heard the discussion earlier about no cost for the hold harmless application, so that's a good solution. Thank you.
Thank you very much.
Okay.
Thank you.
Thank you. All
I'll
right.
make the motion to approve the use of the historical courthouse and courtroom for the Texas Independence Day presentation to the public by Sons of the Republic of Texas, David Crockett Chapter, on Saturday, March 2nd, 2024, from 10 a.m. to 1 p.m., and a rehearsal on Friday, March 1st, 2024, from 5:30 p.m. to 6:30 p.m., subject to a hold harmless agreement with the county.
Second.
A motion been made by Commissioner Samuelson for use of the historic courthouse and courtroom for Texas Independence Day presentation to the public by the Sons of the Republic of Texas, Davy Crockett Chapter, on Saturday, March 2nd, 2024, from 10 a.m. to 1 p.m., and a rehearsal on Friday, March 1st, 2024, from 5:30 p.m. to 6:30 p.m., second by Commissioner Wilson. Any further discussion? All those in favor say aye.
Aye.
All those opposed say nay. Motion carries unanimously 5-0. Thank you. Okay. Item number 16, discuss and take appropriate action to allow MOA, and we see we got the members there, so glad to see y'all, and the Granbury Winter Walk Committee
Wine walk.
to utilize the historic courthouse lawn for a, quote, message in a bottle, living art installation on Saturday, November the 11th, 2023, from 10 a.m. to 9:30 p.m. Yes, ma'am. Please introduce yourselves. Some of y'all are so well known we don't need this, but for the record.
Hi, I'm Amy Winters. I'm helping with the Winter Wine Walk, and just talked to Gail. She's with MOA.
How are you doing?
I'm Gail Joyce, and I'm
Pull it down.
representing MOA today.
Pull the mic down.
Thank you.
Everybody knows who you are, Gail
Yeah.
Joyce, okay? Please tell us about this.
We just wanted to, since the Winter Wine Walk was falling on Veterans Day, we wanted an opportunity to celebrate the veterans. And so we met with Gail, and we kind of came up with this living art installation that would just be on the courthouse for that day, and then it would be taken away. So the idea is that participants of the wine walk or any of general public would have an opportunity to write a message of thanksgiving in a bottle to a veteran. And then we would display those around the courthouse. They would be filled with sand, light, a small light, and then an American flag. So that would create like a beautiful experiential art piece. And then we would clean up at the end of the night. And so it would just be a living art piece, a beautiful photo op, just to celebrate and give thanks to our veterans.
Are you in favor of this, Ms. Joyce?
Yes, and I really appreciate the opportunity to be here today to thank Judge Massengale and the commissioners for your support of our Honoring Hometown Heroes program, which we get a lot of publicity from across the state of Texas. And I've even had calls from as far away as Indiana, who has happened to see a picture of a relative that was one of their veterans on one of the banners. So it's a very popular program, and I thank you very much for your support for that program. And I think this is a great opportunity. More will provide the volunteers to fix the bottles, put the sand in the bottles. People always appreciate an opportunity to thank their veterans and remember their veterans. And these will have the names of the veterans outside on the bottles as well, and the participants can come back and pick up their bottle and take it home with them if they so choose. So MOA will just be there. It'll be an opportunity for us to provide some information about the Military Officers Association of America, as well as our Honoring Hometown Heroes and Field a Flag program.
Perfect.
Any questions?
Any question or comment? Great. Y'all do a great job. I mean, really, I'm looking forward to this. This is going to be great.
Yes,
So
thank you. I think it's going to be a beautiful presentation and a wonderful way to remember our veterans and thank them on Veterans Day.
Good deal. Well, thank both of you for all that y'all do for the
Yeah.
veterans, too. Looking forward to it. Thank you very much.
Thank you.
Okay. Okay, do I hear appropriate motion?
Yes, I move that we allow MOA and the Granbury Winter Wine Walk Committee to utilize the historic courthouse lawn for a message in a bottle living art installation on Saturday, November 11th from 10 a.m. to 9:30 p.m.
Second.
With the, let me add, with the signing of the document to come from, county legal, on that, just like we've talked previously on the two previous issues.
Okay. Okay. Second by
Still
Commissioner
second that,
Andrews.
yes, sir.
Okay, motion been made by Commissioner Wilson to allow MOA and the Granbury Winter Walk Committee to utilize the historic courthouse lawn for Message in a Bottle living art installation on Saturday, November the 11th, 2023, from 10 a.m. to 9:30 p.m. in accordance with the signing of the appropriate documents from the county, second by Commissioner Andrews. Any further discussion? All those in favor, say aye.
Aye.
All those opposed, say nay. Motion carries unanimously. Good luck, looking forward to it. Thank you, ladies, very much. Okay. Carries 5-0. Now, Melissa Welborn, discuss and take appropriate action to give direction on how new hires, transfers, and promotions will be handled moving forward in the 2023-2024 fiscal year. Melissa Welborn.
Yes, good morning. I received a copy of the matrix that the court approved during the budget process. I noticed there were 3 departments or categories that there is a starting pay designated for: custodians, clerical, and jailers. Moving forward, we always have issues where maybe we do find an experienced jailer or an experienced clerk, or someone leaves the matrix maybe at a higher level than starting pay. So my question is, what is the desire of the court moving forward? Do you require all department heads to bring any position to court for approval other than either a step 1 or starting pay? Do you want to take court action on those, or do you want to just leave it up to the department head that if they feel they have found a candidate that needs to start, let's say a clerk 3 instead of at the starting pay, or they promote from within and they want to move them to that particular position? Is the court okay with the department head doing that, or do I need to put that on the agenda and let's bring it to court, and then the court decide if that person, or yes, that candidate, applicant should be placed at a higher step than what the starting pay is.
Yeah, this has been something that we've discussed quite a bit. There often will lose somebody with 20 years of experience, and the new person comes in at exactly the same salary. And it gets your matrix all kinds of crazy because you have somebody brand new making way more money than somebody that's been here for 15 years because they just step into that same salary. I think we need to have a policy where you go to the beginning of the matrix, your new hire goes to the beginning of that matrix, and then if there is, because there should be considerations, there are varying levels of experience or something that somebody can come in that may need to adjust that. You can come in and get to make a case for somebody to be moved to a different spot on that matrix, but I think that needs to be court approval. I think that the policy should state that you start at the beginning of the matrix.
So is what?
Otherwise.
Let me see if I understand what you're saying, Commissioner Andrews. So you're saying all new hires would start at either the starting pay or step one, and if the discretion of the hiring manager thinks that that's not appropriate, then they would bring that to court?
Yes.
Okay.
Yeah. Now, there's a sticky point here because I think that we have a policy in place in the sheriff's department according to TCOL experience with those things. So I think that maybe this should be, the sheriff's department should follow that, the guidelines that we already have set up there for them. Am I?
You're talking about the matrix that's currently approved?
Yes. Yeah.
Okay.
Where if somebody comes in, with 6 years of TCOL experience, they don't start at the beginning, that's automatically done as according to that TCOL because we already have a mechanism in place there.
Okay.
Is that correct? Is that what you're looking for? Am I making sense here?
Yes. Or if someone is promoted, are they promoted to the next level based on years?
Well, and that's, I think what we've put in place is you promote to the level where you don't take a pay cut. So
what?
If you're moving from a patrol deputy with 8 years of experience to a corporal, actually that probably, would y'all be okay with just bringing that to court and explaining why that person gets put on that step in the matrix?
If that's what y'all wish, we could do that.
I think that would be okay. I think for new hires coming into the sheriff's office with the TCOL experience, we've got a pretty firm grasp on that. So let that go ahead and play out there. If somebody comes in with 6 years of experience TCOL, you put them on the 6-year slot as a new hire. But then on the promotions, you'll come in and talk about it, and then any other departments where they, it makes sense that, if you're trying to hire somebody with significant experience and exactly what that position is, and you wanted to move them up a couple of steps to come in and get court approval for that.
Okay, so court approval for any type of promotion that puts them on, let's say, a lateral move. 5 years, they need to come and promote that to the court to move them to a 5-year corporal.
Yeah.
Okay.
So let me just reiterate. Oh, go ahead.
Sorry. If we're talking about bringing all promotions before Commissioners Court, as you guys know, our turnover in the jail is quite a bit. Are we talking about jail as well? That'll be, maybe every Commissioners Court, we may be coming to you to talk about that, depending on the turnover in the jail.
So the default is, if I understood you right, that for the sheriff's department, TCOL would define where they land on the matrix.
Yes, at the starting point, at a new hire,
But what-
going
and-
in the deputy,
but for
deputy in
promotions-
jail.
But for promotions, That's what I think he's asking about. So,
Well, it was the same thing for the sheriff's office deputies. Let's say a deputy promotes to a corporal. If they want to bring that deputy in at the same year of experience to a corporal position, I believe I'm hearing they need to bring it back to court instead of starting at the bottom or the starting pay of a corporal.
Right, yeah, if you're a 5-year deputy and you're moving into corporal, what we've done in the past is just move you to the next step that gives you an increase. And I still, excuse me, I still would like to see those matrices or matrices adjust a little bit where that happens with everybody, but I think that you're going to get a first-year corporal. Maybe that was a 5-year deputy, they get promoted to corporal, that they would take a pay cut to slide into the first-year corporal slot, so we would need to move them up the matrix in order to give them an increase to take on the additional responsibilities. So I think at that point, it would, unless we could figure out a way to put that into words that, as a policy, then, anybody that moves into or gets a corporal promotion starts at Corporal 1 unless brought to court and directed otherwise.
Other than the sheriff's department, is this a problem with anything else? I can see where law enforcement officers may move around with prior experience with TCO, but for any other department, it's not.
It could be.
Oh, it's.
Yeah, it could be. If we have a tenured employee who retires, leaves, and that department head wants to promote or hire someone in at where that salary was left, it's possible.
It's frequent that,
And on that
does happen. So.
Yeah, and then on the other hand, if somebody leaves and you find someone that's worked in another county in that exact same position but has moved to Hood County and they have 10 years of experience, there should be some discretion in hiring them at a higher salary level than the starting pay, since they have experience doing that same job in another county.
If the budget is there, yes. And then that's another question I had. If the budget is there, does the department head have to bring it to court to hire an applicant who they feel is qualified to take that higher salary? Or is it just a given that that department head gets to hire that applicant in at that salary that was vacated?
Well, and I think that that's where we've been in the past, that I see a problem with, and I think that we need to get away from that because, again, you've got somebody brand new coming in making the same amount of money that somebody been working here for 18 years, and somebody that's been here 10 years is making significantly less than that brand new hire.
And I think that's where what you said at the beginning was all new hires start at the beginning step, whether it's step 1 or starting pay based on the matrix. But if the hiring manager feels that that person's experience places them at a higher level, they bring that to court.
Whether the budget is there or not?
Well, I think
one of the concerns I have is we have department heads that are in that position, and, are we trying to micromanage them? And that's a slippery slope you got to be careful on also. So we don't need to be micromanaging. Yeah, we're the stewards of the monies for the county. I understand that without question. But the bottom line is, why do we have department heads if they've got somebody that comes in with 10 years prior experience, as was just stated, having to come back to court, go to exec session to discuss that individual, which is what we're required to do, and then with no discretion on the, department head at that point. So we don't need to be micromanaging, but we need to manage.
Like I said, we've got plenty of examples where new people are making significantly more than, because everybody's just always traditionally
probably not everybody, that's too broad a statement, but frequently, somebody will hire brand new in at the previous person's salary, and I think that sends a bad message.
If it does turn out to be overburdensome, we can always change.
Okay. So you want me to bring a policy back next court?
Yeah, I think we need to have a policy. I think it needs to
Okay.
be, it may be kind of a little wordy to try to figure some of this stuff out, but I think that we do.
But I'm hearing anything really above a 1 or a starting pay salary needs to come to court. Is that what I'm hearing?
Yeah, I think so.
Sir?
If I could get some clarification on that, if I have a deputy with 5 years' experience that wants to apply here, are y'all saying y'all are okay with me go ahead and starting them in the correct step, not step 1 at that time?
Yes,
Because if
because
everything's got to come through court, that's going to delay the hiring process and everything.
Right, no, because we have a very well-defined mechanism for you guys, and that's that it starts on TCOL date.
Okay.
So that's what I was saying. I want to make an exception for the sheriff's office because there is something in place that makes sense, where you can get the lateral transfers to people with experience to come in and put them on the matrix at the right spot. We finally got your matrix kind of corrected and based on experience, and I don't want to.
You have several categories of salaries for that purpose,
Yes, ma'am.
and then additional cert pay that can be moved.
Sure, I'm just wanting to make it clear that we don't have to bring them in at a step 1 if they've got 18 years' experience.
Correct.
Okay.
Okay, and then I just want to clarify that even though the person that left may have left at a year 1, so it's a $61,800 annual salary, but we find someone with 5 years, we're good to go, auditor?
Yes, ma'am, unless, again, just come work with me, because we can do adjustments during the year that keeps you in that budget. And Steve and I have talked about that numerous times. You know, there are placeholders. And we work within that to keep them in their current budget. And that's what's really important with you guys. You need to keep them with all departments within their current salary budget.
Yeah, and that's part of the work that took place over the last few months.
423 days and 12 minutes.
And that's why I'm here.
Yes,
That right there. But you're not requiring court approval to accommodate what Chief Smith just said about new hire deputies.
Correct.
Okay.
On
It
TCOL
just goes by
and jailers,
TCOL.
because the jailers have TCOL experience also.
So I think when you define it, you would just say any jobs that is covered by TCOL.
I don't know that the matrix is defined like that as far as the jail goes, as far as TCOL service.
It's not, but again, you have a variety of salaries, and they can be worked within that budget. And that's also the same thing with the jail. You have a variety of salaries on open positions and new positions. So you work within those parameters. Those are on the matrix. If you have someone that has 10 years' experience, just get with me and we'll get it straightened out.
But I do see what you're saying. That's pretty fuzzy math there. I see. Because the matrix for the jailers is not specifically.
Yeah, it's not like the deputies.
Lined up as years of TCOL. It's more of a step
There are
situation,
enough,
so.
there's enough open positions that you can work within that and stay in your budget.
And that is correct. There will always be enough, more than likely, enough
Right.
salary. But I need direction on how the court wants me to handle those.
What about an example, though, such as road ops? I mean, if he's got somebody that's got 10 years' experience running an excavator or a ditch, cleaner, whatever, is he, are you proposing that they have to come to court to get approval, other than start 1?
And that is a great example. I'm talking about all departments, not just sheriff's office.
Right. Yeah.
I mean, that's a prime, because if Don has somebody come in, that's got, significant prior experience, you're taking away his judgment, in my opinion, of what to offer that, or try to get that individual to come to work for the county.
I mean, I can see the point, but I don't know, outside of that mechanism, having him come and ask, it's still available, it's still there. You can still hire somebody in at a higher step. I don't know, unless we can figure out a way to quantify road ops steps and say this person has checked all these boxes, so they should be at this particular step. I don't know how we would do that.
I think you're micromanaging a little bit. When I bring people in for an interview, sometimes they ask the questions of salary pay. I need to be able to answer them right then and there. And so if it's in my budget and I've determined what I can pay out of my budget, I should be able to do that. If it goes above my budget, then I come to court. So, I mean, you've approved a budget. So if I can stay within those standards, then I should be able to make decisions on hiring and what the salary should be, as long as it's within my budget. Now, if I have to go above my budget because of experience, then I come to Commissioners Court and get approval. And in the past, it's always been, a step 6? You can't go above a step 6, and then you'd have to come to court for approval?
That has been the practice in the past, yes, but our matrix is set up a little different now, so that's why I'm here.
Yeah, and it almost ends up to where, nobody hired anybody at the first 5 steps on that matrix. On the step, they just went to step 6 to start. So it was kind of the same thing. That's kind of the starting spot on that. But no, I mean, I can understand what you're saying. I see, but I think that there's still an opportunity. There's still, a leeway a mechanism to get the salary that you need to get, but
Well, if it's
keep from...
Maybe you put that mechanism back in. If it's above a step 6, you come to court for permission. I don't know what the fix is, but I think you should be able to spend your budget.
What do other counties do about this? I can see that. I like having, like road ops, somebody with non-Lenny's experience. He has a guy that comes in and wants to hire him, and he's got it within his budget to hire him at a certain deal, to go ahead and do that. What do other counties do, like Erath or Johnson or?
Well, I can't speak for other counties. Now, more than likely, most counties don't hire anyone above what was already budgeted, which that's not our practice either. But what I'm hearing is if you have the budget, because a lot of departments have the budget, whether that position was budgeted at a certain amount or not, because they never have a full department. There's always the budget. So, sure.
And that's...
The jail's a great example there. They're always going to have the budget. So are we saying that if Captain Turbeville found someone that had 5 to 6 years of experience, even though the position was budgeted for 61.8, I believe, is he allowed to bring someone in at a higher step or higher grade on the matrix because the budget is there?
Well, that's where you run into a problem, because the court approved the salaries. That they set salaries October 1st. What everybody in the county is making right now, that's where they set them. So you would have to come and undo that. They set those, like 6 clerks at these salaries. That's where you come into a
So if you have a deputy that leaves at 1 year, they can hire a deputy in at 5 years?
They're going to have other open positions in that case. But clerks...
Not necessarily. The jail is really the only department that I see that going on in, because they're never fully staffed.
But again, you have numerous salary schedules in there. But where you run into a problem with this is with the clerks.
Well, most of our clerks are A1 or starting pay. And so then my question is that department head, like the county clerk just said, I should be able to hire that person in at whatever salary I see fit, as long as it doesn't go over my budgeted salary? Or do they have to start at starting pay or come bring it to court?
I think what I'm hearing is that we need to have time for you to write up an example of a policy and then bring it back to court, based on what you've heard.
Okay.
I'm not sure we can.
I'll work with Commissioner Andrews, and, because I know he's worked quite a bit on the matrix. We'll try to get something together and bring it to court.
Okay, so I'll move that we table this discussion, the action to give direction on how new hires, transfers, and promotions will be handled moving forward in the 2023-24 fiscal year, pending a draft of a guideline policy.
Okay.
Second.
Motion been made by Commissioner Samuelson to table the action for new hires, transfers, and promotions, second by Commissioner Wilson. All those in favor, say aye.
Aye.
All those opposed, say nay. Motion carries 5-0. Good luck on that,
All
Ms.
right.
Walber.
Thank you.
I think you better have Ms. Becky Kidd on that, too, so try to come up with something on that. Thank you very much. Okay, that brings us to the consent agenda. Does any commissioner wish to pull anything from the consent agenda? If not, do I hear a motion?
Yes, I move that we approve the consent agenda as stated.
Second.
Motion been made by Commissioner Wilson to approve the consent agenda, second by Commissioner Eagle. Any further discussion? All those in favor say aye. Aye. All those opposed say nay. Motion carries unanimously. Okay, road ops, Mr. Donald Lenny. Yes, sir.
Good morning, Judge Massagill, Commissioners. First, the thing on our agenda for road ops is discuss and take appropriate action on accepting the following roadways in Comanche Cove development onto the county road system. Hood County has received a request, a petition for the three that are labeled here. It's Tree Drive from Thicket Trail to Elk Trail. It's 440 feet in length. Sabine River Trail from Pecos River Drive to Colorado River Drive is 725 feet. And this, I've never run into this before, but it's actually a lateral cul-de-sac that's part of Thicket Trail. And in your backup, it's the last page on your backup, and I've got it highlighted what it does look like. It's in the 900 block of the Thicket Trail roadway, and it's 85 feet in length. Total, these are 1,250 feet in total, which is about 2/3 of a mile in length. After speaking with Commissioner Samuelson, I did go out and look at these three requests, and they do adhere to our policy of acceptance into the county road system.
Okay.
Road Operations does recommend accepting these three sections of roadway into the county road system.
Okay. Any further questions or comments? If not, do I hear an appropriate motion?
Yes, I'll make a motion to accept the following roadways in the Comanche Cove development onto the county road system. Tree Drive from Thicket Trail to Elk Trail, 440 feet. Sabine River Trail from Pecos River Drive to Colorado River Drive, 725 feet. Thicket Trail, which is a lateral cul-de-sac, 900 block, which is 85 feet.
I hear a second?
Second.
Okay, a motion been made by Commissioner Samuelson to accept the roadways as stated into the county road system with the recommendation of Don Lenny, second by Commissioner Andrews. Any further discussion? All those in favor say aye.
Aye.
All those opposed say nay. Motion carries unanimously. Thank you, Mr. Lenny.
Thank you, Judge.
Okay. Next, Mr. Clint Head, Development. Number one, set a public hearing for the replats of the landings and Oak Hill Shores. You got a date?
Staff recommends setting that public hearing for November 28th, Commissioners Court.
November the 20th?
8th.
8th?
November 28th.
28th.
2023. Okay. Do I hear a motion?
Yeah, I'll make the motion to Set a hearing for the replat of number 1, the Landings Lot 3262R in Precinct 2, and number 2, Oak Trail Shores, Section C, Lot 52R, Block 1, for the November 28th Commissioners Court.
Second.
Got a motion made by Commissioner Eagle to set public hearing for replat of the Landings and Oak Trail Shores for November the 28th, 2023, second by Commissioner Andrews. Any further discussion? All those in favor say aye. Aye. All opposed say nay. Motion carries unanimously.
Judge, if you allow me just 1 second to briefly touch on what the city was recommending, that way I have all y'all together and don't get bombarded after this. To do what they want to do, we already district. We have the Water Quality District. So what they're talking about, the Development Commission, it would require, that was wrote way before 2019. 2019, they stuck a time clock on us. We'd have to completely overhaul our regs, and it would take the Commissioners Court out of the equation for approving plats because of that time clock. It had, I mean, everything would have, y'all would have to earmark about $250,000 to completely revamp the development regs. And then, what they're talking about, land use zoning, instead of us doing the Water Quality District, that's a completely different bird. There's probably ad hoc committees and all kinds of public hearings if you're going to tell people, all right, you're going to use this property for commercial and you're going to use this for residential. So, I mean, that's a huge undertaking. So it's not something, it's something y'all need to earmark some money for if you want to do it, and maybe another department.
Maybe the city will pay for that.
I mean, I don't love the idea of telling somebody out there in the middle of, judge telling you, what are we going to, is your property going to be commercial or residential? That's, I think we ought to leave that to the landowner
I don't mind
to decide.
overhauling the regs, but that development commission with the time clock, it would be impossible unless we took y'all out of the equation.
Yeah.
There's a reason people live in the county and not the city.
That's the difference between a home rule city and a county, too, so I hear what you say.
Okay.
Thank you for
Item
your...
number B, discuss and consider the preliminary plot of Biloxi Valley Ranch.
The concept plan, well, it was approved a couple of months ago. I forgot about the date. And it has a gross site area of 312 acres, 312.08 acres of the J. Peacock Survey, abstract number 696, and the William H. Pate Survey, abstract number 447, and the John W. Earp Survey, 173 in Hood County. This property is located at 11819 Bakers Crossing Road, Bluffdale, Texas. This property is located partially within the Water Quality District, partially in the Road Corridor District, and partially in the Rural District in Precinct 1. And all lots are proposed to be served by well and on-site sewage facilities. This preliminary plat proposes to dedicate 16,957 acres of right-of-way, or no, 16.957 acres of right-of-way. The smallest lot proposed is 2 acres and largest is 12.43 acres. This preliminary plat is proposing to construct 11,954 linear feet of private streets, which are to be constructed of 8-inch flex base and 2-inch hot mix. Staff has reviewed this preliminary plat. All comments have been addressed and recommends approval as presented.
Okay. Any comment or questions? Do I hear a motion?
Yeah, I'll move that we approve the preliminary plat of Biloxi Valley Ranch.
Second.
Motion been made by Commissioner Andrews to approve the preliminary plat of Biloxi Valley Ranch, second by Commissioner Samuelson. Any further discussion? All those in favor say aye.
Aye.
All those opposed say nay. Motion carries unanimously 5-0. Next, discuss and consider the final plat of Waymaker Estates.
This final plat is a subdividing of 9.994 acres of the J.J. Cody Survey, abstract number 139. It's located in the Rural District in Precinct 1 and proposes to create 4 lots that will be served by well and on-site sewage facilities. There are no streets being proposed with this plat application. 2 of the proposed lots will utilize a shared access ingress-egress easements. The smallest lot is 2.01 and the largest lot is 3.962 acres. There are no variants associated with this final plat. Staff has reviewed the final plat. All comments have been addressed. Staff recommends approval as presented.
Any questions or comments? If not, do I hear a motion?
I'll move that we approve the final plat of Waymaker Estates, lots 1 through 4.
Second.
Motion been made by Commissioner Andrews to approve the final plat of Waymaker Estates, second by Commissioner Samuelson. Any further discussion? All those in favor say aye. Aye. All opposed say nay. Motion carries unanimously 5-0. Next, discuss and consider Section 9D of the Hood County On-Site Sewage Facility Order in relation to regulatory takings as it relates to existing and future development.
I put this item on the agenda to bring the court's attention to the language in Section 9, more stringent requirements, Section D of the OSSF order that was recently approved. I did not see this order until after it was approved. The language prohibits the installation of an OSSF in the floodplain or within 200 foot of Lake Granbury or within 200 foot of the Brazos River tributaries, which could be any creek, any kind of runoff. There are several issues this creates. First, there's a lot of properties that will be rendered useless until public sewer becomes available. Since there is no definition of tributaries, like there is in the Water Quality District regulations and the development regulations, is to be taken to mean all creeks and tributaries. Back in 2020, when it was discovered that similar language existed in the development regulations, FEMA at that time was expanding a floodplain at one of the developments in Precinct 2, and we rushed to correct this, and there will be floodplain changes in years to come, and you just never know. Anyway, Commissioner Precinct 4 helped me define that then, because we just went with, we quoted the statute, we referred back to the statute, and that cleaned it up, and it allowed those houses that weren't in the floodplain that now are in the floodplain to have a sewer. Since this is a new order and staff doesn't want to be in the position of not enforcing our own regulations, and it supersedes my development regulations now, I just wanted to bring this forward and discuss options of correcting this because it can be construed as a taking. The properties are now unusable. One option for the court chooses to omit or amend Section D, which conflicts with the floodplain regulations, the development regulations, and Section F of the same order. This would require going back through the process of TCEQ, and in my opinion, clears it up, but we all know it's not a fast process. Another option is to take advantage of the severability clause in Section 13 that allows you to void by a valid judgment or decree any part of the order without affecting the remainder of the order. There are many cases on regulatory takings that could be cited and crossed out and put that on the one we publish on the website. The only other option I can think of is if y'all choose to, I can run a public notice in the paper for a countywide variance for this section.
What do you recommend?
That's up to y'all. I mean, if y'all attorneys think that we could use a severability clause, that'd probably be the cleanest, easiest.
But this is, this wasn't new in the OSS order that we just passed. It was in the prior order.
And it was reworded and has a date in there, which kind of creates a new issue. Otherwise, our development regs that we corrected in 2014 would have, 2020 would have superseded this. But since that date was put in there and changed it, we actually have a house in one of our new developments that's sitting there with a sewer, without a sewer. It's about $1 million house, and it won't get a sewer if we use this.
So this, you know, if...
Have you talked to Matt Mills about this? What does he suggest? Come on up, Mr. Mills.
I think my first thing would be just to email the same TCEQ officials that we were in communication with before, because if you just, you know, deleted something and then they got wind of it and said that that invalidated our order, I don't want to, you know, run afoul of TCEQ. So, I mean, get them in the loop, let them know that the issue that has come up, that we want to void this clause or amend it in some way, and just take instruction from them. But I don't want to go through a full revamp, like he said, of all the postings and notices, and that was kind of a long, arduous deal. So I'd like to be able to just strike whatever's unenforceable with their permission.
So what we're going to have to do is to draft something and send it to TCEQ. That's...
Well, I think what he's saying is use the severability clause with their blessing.
Well, yeah, well, you're going to have to get them involved in the process.
I got a concept plan that's coming next court that this kills 63 lots in.
So what I'm confused about is this was already there, so how is it not in conflict?
When we changed the development regs, it superseded what was in here, and y'all seen what kind of processes it was TCQ, so we just used the development regs.
So what should have happened is that this was deleted when we changed the OSSF.
Ideally, yes.
Okay, so no one mentioned that in the months that we were going through it.
Can I say something?
Sure.
It was not put on as a more stringent deals. I don't know who put the date in there, but it was not listed as a more stringent item, but you did change it and put the date, February the 25th, 2014.
Because the old order, under the more stringent guidelines, said that,
It had no date.
right, it said at the adoption of this order. So for it to reflect that it was adopted with the prior order, the date for the prior order.
Also adopted in 2007 or 8 and 2001. It's been in the order from basically the beginning. I do not think there was anything on the 1999 order, but it had, that wording had been there, in there, but it didn't have a date stamp on it, and the county had never enforced that. Now you put a date on it, and I have $1 million home sitting in a subdivision. I'm holding the septic, and the time clock is ticking. 45 days, they'll be back up here.
Since it makes it unusable till a central sewer system becomes available, in my opinion, I think a jury would say, yeah, you're made the property worthless, so it would be a regulatory taking.
So we should have deleted that whole section, but that's not, I mean, that didn't have anything to do with the OSSF.
We've been through it and seen it in 2020, that floodplains move, and as more gets developed and technology becomes available, and we have more hurricanes and they learn more about them, those floodplains are going to move, and you might be making all kinds of properties worthless.
They're not working with a static environment. So,
There was a date. I mean, the date that was in the old order said that are created on the effective date of this order. So by default, the date was the effective date of this order, which is what when I saw that, we didn't want to change it to be the new effective date. So the effective date of this old order was February 14th, so that's the date I put in.
When I was looking at it with Kevin, we didn't see where it was bolded or redded, where that section had even changed, but it would definitely changed.
So it should have just been deleted, but.
So what's the pathway forward here? To ask TCEQ if we can strike that due to the severability clause?
That'd be my take, and then we can put that on the agenda in 2 weeks, along with any other stuff that needs to be approved at that time. That'd be the quickest, easiest way to do it, I think.
Well, let me ask you this. Could we make a contingent right now that if TCEQ approves that? I don't anticipate that they'll do that in, a 10-minute phone call down there, but if we've got something holding up because of it right now, could we contingently approve that now so that if TCEQ gives their blessing on it, that we can go ahead and go with it instead of having to wait till the next court?
Well, I mean, you're talking about stuff that's not on the agenda specifically.
Okay, gotcha. Okay, all right. Well, then I guess we need to see if we can run that trap. So.
That's the only options I can think of.
Am I correct? Okay. No.
I mean, we can get with TCQ starting in an hour and,
See what their guidance is.
Yeah.
So.
Definitely going to have to get TCEQ involved in
Right.
it, make them aware of the problem. That's what we're going to have to do, and put it on the docket. Okay. That's success. Thank you, Mr. Head. Okay, financial, Ms. Becky Kidd.
Good morning, Judge, Commissioners. We have two expenditure amounts for today, old and new budget. That's always fun. Old budget, $415,104.96. New budget, $611,311.50. We have reviewed all these invoices. We've also given you a list of expenditures over $10,000. Anybody have any questions?
Any questions? No. Do I hear a motion?
Yeah, I move we pay the bills of $415,104.96 from the old budget, $611,311.50 from new budget.
Second.
Motion been made by Commissioner Andrews to pay the bills out of the old budget and new budget in the amount stated, second by Commissioner Eagle. Any further discussion? All those in favor, say aye. Aye. All opposed, say nay. Motion carries unanimously 5-0. What else do you have, Mr. Kidd?
We have completed the annual Justice of the Peace Precinct 2 financial review. There are no exceptions with this audit, and we ask that you accept it.
Okay. Any questions or comments? Do I hear appropriate motion?
I move that we accept the 2023 review of Justice of the Peace Precinct 2 financial records.
A motion been made by Commissioner Samuelson to accept the 2023 review of Justice of the Peace Precinct 2 financial records, second by Commissioner Andrews. Any further discussion or comment? All those in favor say aye. Aye. All those opposed say nay.
Thank you.
Motion carries unanimously. And with that, the meeting is adjourned. Thank you very much.